Admission and Confession, Lecture 1. Okay, in this lecture, we are going to look at admission and confession. In particular, we are going to concern with the definition of admission and confession and to look at the distinction between admission and confession. We also will look at who are the person that can make admission and confession, who will it implicates, and basically, if you recall last time, confession and admission is an exception to the hearsay rule. It is an exception to the hearsay rule, however, true with regards to confession, evidence of confession, if it is tendered by the prosecutor as an evidence in the court, it will be a hearsay evidence because it is a statement that cannot be verified by the accused person in the court. And this is a statement that works to the detriment of the interest of the accused person. Okay, the sections that relates admission and confession will be Section 17 to Section 31 of the Evidence Act. Since the focus of our today's discussion is actually to look at admission in particular, the relevant provision that we are going to cover for this lecture is Section 17 up until Section 23. Okay, now let's look at the definition of admission and confession first. Now, the definition of admission and confession can be found under Section 17 of Evidence Act. Now, please remember that this provision only provides you with the definition. So, it provides you with the concept as to what does it mean by admission and what does it mean by confession. So, under Section 17, Subsection 1, an admission is a statement, oral or documentary, which suggests any inference as to any facts in issue or relevant facts and which is made by any of the persons and under the circumstances hereinafter mentioned. So that is basically an admission. Whereas Section 17, Subsection 2 defines confession to mean an admission made at any time by a person accused of an offence stating or suggesting the inference that he committed that offence. Now, when you look at these two definitions, you will find that the scope of admission is larger compared to confession. Confession basically a subset to an admission. All confession are admission, but not all admission are confession. Alright? So now, what is a confession and how do you compare that with an admission? Now, if you have an admission, if you have a statement, right, and you don't know or you are not sure whether the statement is actually an admission or confession, the case of Ananda Goda and the case of Lee Kam Seng basically indicates that a test that is to be used to determine whether a statement is actually a confession or admission is an objective test, right? The objective test is whether in the mind of a reasonable man reading the statement at the time, in the circumstances in which it was made, it can be said to amount to a statement that the accused committed the offence or suggested the inference that he committed the offence. Now, if you look at this test, it is an objective test because you have a reasonable man that would analyze the statement objectively. Yeah, even though it is to be analyzed objectively by a reasonable man, the reasonable man has to consider the statement subjectively, and it has to be looked at the statement has to be looked as a whole, and it has to be considered in its own term. Now, this part of the test reflects that there could be some kind of subjective element be injected when a reasonable man is to use this particular test to determine whether an accused person or whether a person made a statement or whether it is an admission. Now, if you look at this PowerPoint, the distinction between admission and confession is that this admission is a statement that suggests an inference as to any facts, nature, or relevant fact, whereas when you talk about confession, it is a statement made by an accused person saying that he committed the offence. Alright, and if you look further, you'll find some provisions in which more relate to an admission and some provisions that may relate to confession. And of course, the applicability of confession will be only in criminal cases because if you refer back to the definition here, right, it is clearly stated that confession is made by an accused person yeah, suggesting that he committed the offense. Now, how do we relate this? Yeah. Now, I'll give you an example of this one. Okay, so from what we have just now, basically, so we have section 17, right? Section 17, which actually gives you the definition of admission and confession. So under section 17, subsection 1, you basically have an admission, right? And under section 17, subsection 2, you have a confession, right? So when you look at this example, okay, these two provisions, you find that admission can either be, admission is a statement. It can either be orally made or it can be in a documentary form. So say for example, you have a situation where there is a letter. So the letter will be in a document form. The letter is tendered as evidence in the court. It may contain an admission. Then particular letter may fall under an admission. Whereas it is the same as confession. Confession can also be made orally, right? It can be made orally or it can be in a form of document. It means that you may produce a document which contains the confession of an accused person in the court. Now, admission, okay, who can make an admission? If you refer to section 17, subsection 1 there, you will find that admission can be made by the person himself who is being implicated by his own statement. It can also be made by a third party. Yeah? And then, of course, we will further ask the question, who is this third party? Now, the Evidence Act provides you with the person who can fall under third party here, and the third party that can make an admission which implicates a person will be those who falls under section 18, section 19, and section 20, and section 21 of the Evidence Act. So, compared to confession, who can make confession? Basically, only one person can make confession, that is an accused person. So, an accused person can be the one who made the confession. Okay, this will be the general rule. So, under the criminal law, under the criminal justice system, a confession can only be made by an accused person and it will implicate the accused person. And having said that, there is an exception to this general rule where we look at section 30 later. Yeah, section 30 of the Evidence Act. Now, admission is more general in the sense that it refers to a statement which have some inference to the facts and issue or relevant fact. Whereas when you talk about confession, the accused person must admit committing a crime. Okay. I'll give you an example. Right, let's look at an example. Say for example, you have here A was driving his car, right? There was an accident and A made a statement, I was driving the car passing the accident. And that statement made by A here can be regarded as an admission. He never admitted to committing reckless driving. But when you talk about an admission or when you talk about a confession, is where A now made a statement, I drove my car so fast, I was drunk when driving the car, and I knocked him down. So that particular statement can be regarded as a confession. So confession is where you admitted committing a crime, whereas admission is that when you make a statement which have some inference to the facts and issue or relevant fact. Yeah, that is when he say, I was passing by when there was an accident. So it doesn't really reflect that he committed any crime. Similarly, if you have another example, say you have Ali kill Mona, right? There was a knife, yeah, on Mona. So the facts and issue is whether Ali kill Mona, and Ali here made a statement, that knife is mine. Yeah, Ali made a statement, the knife that was found beside Mona is his, maybe because of the engrave on the knife. So he said that knife is mine. When Ali made the statement that knife is mine, he is making a statement which have some inference to the facts and issue or relevant fact. So it will be an admission. Whereas, if Ali say, I killed Mona, I stabbed her 3 times, that will amounting to a confession. So that is how you differentiate between admission and confession. Remember, the test of Ananda Goda will only be applied if you are not sure whether this particular statement is an admission or a confession. Okay? If the statement is very clear that it is an admission or it is a confession, then there is no need for you to apply Ananda Goda's test. Now, if you refer to section, just now it was a definition of admission and confession, which is under section 17, subsection 1 and 17, subsection 2. Now, section 17, subsection 3 says that subsection 2 will not be applicable in Sarawak. This provision, this subsection basically relates that the test of Ananda Goda here shouldn't be applied in Sarawak. This is in the sense that there is no distinction between admission and confession was clearly made. Therefore, admission and confession can be relevant and admissible as evidence in the court, provided that if it is a confession, so if you have confession, you have to look at the definition under section 17, subsection 17, subsection 2, but the relevancy. So if the statement is a confession, the relevancy and admissibility of that particular statement must have to comply with provisions relating to confession, which is under section 24 to section 30 of the Evidence Act. So that is where you have a confession. Now, if you have an admission, right, you got to look at the first provision that you have to cite will be section 17, subsection 1, because section 17, subsection 1 will gives you the definition of an admission, and then the relevancy and admissibility of an admission depends on whether it complies with section 18 to 23 of the Evidence Act. So in this lecture, what we are going to do is actually to look at this part, this part of the provisions of the Evidence Act, which is to look at admission. Okay, now, as I told you just now, right, when you talk about admission, bear in mind, number one, you have to be very clear with the definition of admission. So you look at the statement made by a person. Since it is an inference that relates to the facts and issue, it will be an admission under section 17, subsection 1. If you have a situation here, for example, A is a person that is being implicated. It's the person who is being implicated by the admission. Your concern will be now, who is a possible third party that can make an admission to a person, and the admission here is actually implicating the third party, implicating the person. Now, if you have, if you have an accused, if you have A here, the person implicated made an admission, it is not so much of a problem, because if you made a statement and it implicates you, well, that is well and good, because it is you who made the statement. But what happened now is that if you have a third party here made a statement, and the statement that he made actually implicates you, then it's going to be slightly prejudicial. So if it is prejudicial, the only person that can make a statement which implicates that person will be someone that must be warranted by the law. So, since the question now here is, who is the third party? The third party is those mentioned under section 18 of the Evidence Act. Now, if you look at section 18 of the Evidence Act, now let's read section 18 of the Evidence Act. Admission by party to proceeding, his agent or person interested. So 18 subsection 1 can be divided into 3 kinds of person, right? The first one, under section 18 subsection 1, who will be the third party? Statement made by a party to the proceeding or by an agent to any party whom the court regard under the circumstances of the case as expressly or impliedly authorized by him to make our admissions. So under section 18 subsection 1, the third party that you are concerned here will be either parties to proceeding, or can either be an agent. So if you talk about him being an agent, make sure he has an authority. And when you study your law of agency, authority can either be express authority, implied authority, as well as ostensible authority. So the person who made the statement which implicate A here is going to be one of those two persons. Now let me illustrate to you what does it mean by parties to proceeding. Alright. Say for example, you have okay, A, you have D1. D1 is the driver of a lorry. So he's working with the company, so he drives lorry. What happened was that he was driving his lorry during rainy day, and he actually did not see the plaintiff who was crossing the road. It was at night. So what he did was that he was so sleepy, he knocked P down. So P is now suffered from injury as a result of being knocked down by D1. Now if you recall, when you study your law of tort, he may be a driver, so the owner of that particular lorry could be D2. So D2 could be the company, right? Could be the company, or if it is a partnership, then you are talking about the business. So D2 is going to be the owner of that particular lorry. So what will happen here is that both parties here will be sued, under vicarious liability, where the driver will be your first defendant and the company will be your second defendant. This will be under the law on vicarious liability. Now what happened in this case is that you have a situation here where the driver here made a statement. So the driver here made a statement saying that I was so sleepy at that time, right? It was raining and I don't see the plaintiff here walking by the roadside. So what I did was that I knocked him down. So what D said here is actually an admission, right? And the admission made by D1 here can be used to implicate D2, because D2 in the context of the section are parties to proceeding. So that is what meant by, this will be what provided under section 18, subsection 1. Statement made by parties to proceeding can be used to implicate the other party. So if you have this, let's look at our notes just now. If you have a third party, okay, A here will be your defendant number 2. The third party here will be the driver, defendant number 1. Defendant number 1 here made a statement to the plaintiff admitting that he was negligent. The statement can also be used to implicate D2. This is what it meant by parties to proceeding. Alright? Now the second kind of person, third party, under section 18, subsection 1, will be the agent. Right? An agent can make a statement which implicates the person. Now let's look at this one. How will that be so? So when you have an agent, say for example, you have a situation where you have, okay, this is you, okay, who want to sell the house. So you want to sell your house is at section 7, Shah Alam, is a bungalow, very big, you want to sell it at 3 million, whereas the value of the house is actually 5 million. So you want to sell it at 3 million and the value is 5 million. The reason why you want to sell it under value because your house is haunted. Now what happened here is that if you want to sell your house, you basically enter into a contract with a real estate agent. So you have agent. What this agent do is actually this agent will want to will take some necessary measures to sell the house. Basically, he will advertise at the mudah.com and put the signboard that the house is for sale and whatnot. So what happened here is that katakanlah you have the purchaser P is willing to purchase the house. He is in Dubai, right? He looked at the advertisement. He's going to be back in 6 months' time. So he wants to make sure that he will be, whenever he comes to Malaysia, Yeah, he already have a house, so that the wife who is now pregnant, yeah, they're gonna get baby in 6 months time. All right, they're gonna go straight to the house. So what happened here is that the plaintiff here will be in contact, yeah, with the purchaser here will be in contact with the agent. So in this situation, what happened here is that the agent here, while they were communicating, will definitely going to tell P of the fact that, well, the house is good, it is nice, the surrounding area is nice, you can immediately live in, it is fully furnished. So what the agent did was that giving representation of the fact that the house is habitable, in good condition, and the fact that the purchaser here can immediately go into the house. So what happened here is that after 6 months, now the plaintiff here is coming to Malaysia with the wife, satu anak, daughter who is 5 years old, and also a child, another baby which is 3 months. Now the moment they step their foot at the house, this 3 months old never stopped crying. And suddenly the 5-year-old girl said to the father, I saw a little boy about my age running along the garden dekat belakang rumah. And then what happened was that night, yeah, since the child did not start, what happened was that in the morning the wife discovered that she woke up in the bathtub, and the plaintiff here woke up in the garden. So what happened now here? The plaintiff here now is going to sue the seller here for breach of contract, because the terms of the contract is that the house must be in good condition, it is habitable, and because of that, since it is haunted, the plaintiff here may want to sue the seller here for breach of contract. So what will happen here? The agent may become the plaintiff witness. He may go to court, and when he testifies in the court, he will say that, right, the house, yes, I admitted the house was in good condition. I'm representing my the purchaser, the seller here. Yeah, basically the house was in good condition, blah blah blah. So what he did was actually he is performing his duty as an agent. He has the authority, and that statement that he made is a statement made as an agent that can be used to implicate the seller, right? So this will be a situation under Section 18, Subsection 1, agency relationship. Okay, you have actually a case in Malaysia that illustrates to you the position of how an agency relationship can be used, where admission of an agent can be used to implicate the person. So this is Section 18, Subsection 1. Now, right. Then we also have Section 18, Subsection 2. Now let's look at 18, Subsection 2. 18, Subsection 2 refer to statement made by parties to suit, suing, or sued in a representative character are not admission unless they were made while the party making them held that character. So here you are talking about the third party to be a person who is sued and being sued in a representative character. What does this mean? Right? Now to illustrate to you this one, say for example, you have here Ali. He was driving his car at Taman Perumahan. Yeah, the signature said that he has to drive only at 40 km per hour. But what he did was that he was driving at 80 km per hour. So while he was about to pass one house, right, suddenly there was a boy who is 5 years old, right, jump out of the car, cross the road to go to the park, which is the opposite of the house. So he cannot put up a brake, so he knocked the boy down. So what you have here, so you have here Ali, and you have the victim here who is a boy of 5 years old age. Yeah. Now in this situation, the boy katakanlah his leg has to be amputated, he cannot walk anymore. So the boy is going to sue Ali for negligence. But under the civil procedure, the boy who is a child here, a minor, cannot take action himself. So what will happen here is that the father who is acting as next friend will be taking the action on behalf of the boy here in court. So under section 18 subsection 2, right, you're talking about a situation where the father here is taking an action on behalf of the boy in a representative character, that is as next friend. Yeah. Now, katakanlah this particular father made a statement. The father said, yeah, my son who is 5 years old is very naughty. He always, whenever he see a taman permainan ke, he will always go there and without looking left and right. So last time pun dia pernah nak accident. So that is a statement made by the father. So the statement made by the father here is actually an admission, right? It is an admission which you use to implicate the boy, right? So if he made a statement to Ali, so you have a situation here, the father may made a statement to Ali and it is used to implicate the boy. So the statement made by the father here can be used, it is binding on the other person, yeah, in a because he made the statement in a representative character. Similarly, if you have the trustee, yeah, if you have the trustee beneficiary relationship, so you study you punya law of trust, basically the actual beneficiary or the actual owner of that particular property could be the beneficiary. So if there is dispute relating to the property, what happened here is that the trustee is going to take action on behalf of the beneficiary. So if the trustee here is making a statement, so the trustee here is now suing or sued in a representative character, the trustee statement, right, can be used to implicate the beneficiary. So this is what it meant by section 18 subsection 2. Okay, now, right, the third one under section 18 subsection 3. Yeah, under 18 subsection 3, let's read. Statement made by person who have any proprietary or pecuniary interest in the subject matter of the proceeding and who made the statement in their character of persons so interested, right? Persons from whom the parties to the suit have derived their interest in the subject matter of the suit. So under section 3 here, you are talking about interested person, right? This is interested person. The interested person may obtain dia punya interest by virtue of some kind of proprietary interest, or it could be pecuniary interest, right? Example of proprietary interest is when katakanlah if you want to purchase a house, the price of the house is 500,000 ringgit. You don't have the money. What you did is you obtained a loan from the bank. So the bank is acquiring interest, pecuniary and proprietary interest over your property. Yeah. Example of this one. Say, so this is you. Okay, you have here, katakanlah Ali want to sell the house to Abu. And then of course the house is currently being charged to Maybank, right? The house is currently being charged to Maybank. So the Maybank obtained interest of that particular house by virtue of a loan agreement, because Maybank actually helped Ali purchase the house maybe 10 years ago by giving them a loan, and as a result a charge has been created. So in this context, Maybank here will have some kind of proprietary or pecuniary interest over the property. Now what will happen here, katakanlah the manager of the Maybank, which is the agent of Maybank, made a statement, right? He said that, this manager said that, he made a statement to Abu, katakanlah, he made a statement saying that Ali has never serviced his loan, he has been in default of his loan for 1 year now. So that is an admission made by the Maybank manager to Abu, and that admission can be used to implicate Ali. So that is the situation under section 18 subsection 3. Okay, now the second, so that will be the first one. The third party that we have discussed just now will be under section 18. Now Secondly, you have the third party that can make a statement which implicate the person is basically the one that falls under Section 19. Now let's look at Section 19. Section 19 refers to admission made by persons whose position must be proved as against party to suit. Statement made by persons whose position or liability it is necessary to prove as against any party to the suit are admissions if the statement would be relevant as against those persons in relation to the position or liability in a suit brought by or against them. So you're talking about a situation where the admission made by the person under Section 19 here creates some kind of liability on the part of the person that is being implicated. Now you have to understand that under Section 19 here, the third party here has no connection, right? It has no connection with the person implicated. So A here is a person implicated, but there is no connection between A and the third party here. Different from Section 18 just now. Under Section 18, there's a degree of connection between A and the third party, and the connection can be seen by virtue of their relationship being parties to the suit, being an agent, being interested party. So under Section 18, subsection 1 until 3, you find that the third party here and the person implicated here have some degree of connection. But under Section 19, there is no connection between the person implicated here and a third party. Okay, I'll give you an example. Katakanlah you have here, alright, you have here Zack. Zack is a very rich person. He has 1,000 houses and shop lots. So what happened here is that Zack is migrating to Dubai. So since he's migrating to Dubai, he don't want to face any headache in managing dia punya property dekat Malaysia. So what he did was that he entered into a contract of service, right? Contract of service with katakanlah A, right? The contract of service with A, whereby the contract of service reflect that A has to collect rent from all the punya tenant, right? Update dia punya record book and then bank into his account and basically give account as to what transpired in the agreement or whatever. Now what happened here is that, okay, you have a few tenants. Katakanlah you have X, Y, and okay, X and Y, yeah. X and Y here were tenant, yeah. They were tenants of Z. They have been renting the house since 2017, right? Dia nak migrate 2020. So what happened here is that X and Y have been paying rent since 2017. But the moment A took over, yeah, since 2020 here, yeah, A never went to X and Y to collect rent. So he did not do the collection of rent from X and Y. So X and Y have been staying in the house since 2020 for free. So what happened now? You have Z here unhappy with A. Z is now suing A for breach of contract of service. Now, when Z is suing A for breach of contract of service, Z now wanting to call X and Y here to give evidence in the court. So they become the plaintiff witnesses. Now what will happen here? X and Y will tell the court of the fact that, okay, yeah, I've been staying in the house since 2017. However, since 2020, no one come and collect the rent, so we stay for free lah. That is what's said by X and Y. Now the statement by X and Y here is an admission, reflecting that A here has committed some kind of a liability, that is non-performance of his agreement to collect rents. So this admission made by X and Y here can be used to implicate A when he testified in the court. You got that? So that is a position under Section 19. So the position under Section 19 here is that the third party has no connection with the person being implicated. However, the admission made by the person may create some kind of liability, therefore it can be used to implicate the person. So that will be under section 19. Now let's look at section 20. Section 20 is another section in which you're talking about who is the third party. Now refer to section 20. Right. Third party, admission by person expressly referred to by parties to suit. Statement made by person to whom a party to the suit has expressly referred for information in reference to a matter in dispute are admission. So you're talking about here, third party will be someone that is referred and agreed upon to be referred to by both the plaintiff and the defendant. I'll give you an example. Say, for example, you have A and B. A, B and C. They are all close friends. They were very, very close together when they were in university. So they have decided to open up a business where they will have their equal share. So they have actually verbally agreed that A will do the management, B will do the marketing, C will be doing some kind of maybe injecting some kind of money, whatever. So they have agreed upon and the share, the profit will be distributed equally. So they want to open up a business. Suddenly, at the end of the day, C said to them, I'm sorry, I cannot be part of your business. I have to balik kampung and maintain and take care of my father. But dia kata, I will support you punya dua-dua punya business. I will pray that you all will be well and good. So A and B says that, fine, we're just going to proceed with the agreement that we had earlier. Kecuali you je tak ada, we are going to move on and do our business. That is what said by A and B, right? After 1 year of doing business, their relationship turns sour. They are now in dispute, so they are suing each other. Yeah, they are suing each other for maybe breach of partnership agreement. There were no written agreement, katakanlah. So what will happen here is that they were having a dispute. A was saying that our terms of agreement should be 1 and 2. And B was saying, no, our term of agreement is 4 and 5. So they are in dispute as to what their terms of agreements are. So what happened here is that they decided that, okay, since we cannot reach into an agreement, what are terms of our agreement? Let's refer to C because C know what happened. Okay, B pun kata kita refer pada C. Now this here, C will be the person that is referred to by both of them. So if C made a statement which is an admission, the statement made by C here can be used to implicate both of them. So the statement here will be binding on both of them and they will be stopped from denying the statement made by C. So this is what it meant by section 20. So you refer to the third party here to be C, the person that has been referred to by both parties. Okay? So you got that. So these are the third party referred to under section 18, 19 and 20. Now let's look at what is there in section 21. Now section 21 here refer to a statement that could be made by the person implicated himself. And katakanlah A made a statement to B, so the source of the statement is actually A, and it is used to implicate B if B is to, used to implicate A if B is to testify in the court. Now in this context, you will find that the source of the statement is A, so it implicates A, so it's not too bad because he is the source of the statement. Section 21 also refer to, you have A here, a third party made a statement to B, B testify in the court implicating A. So it can be a third party admission or a first party admission. Now, our discussion in section 18, 19 and 20 just now all refer to a third party admission. That is this situation. But under section 21, this is one of the provision on admission where it can be a first party admission. Okay, that will be under section 21. Now, let's look at 21 sub A. Now, 21 sub A refers to this kind of situation. Yeah, a third party admission. So what is 21 sub A, right? An admission may be proved by or on behalf of the person making it when it is of a nature that if the person making it were dead, it would be relevant as between third persons under Section 30. Now, if you look at Section 21 sub A here, it has some connection with Section 32 sub 1 sub A, which is dying declaration. Now, this will be the illustration to reflect that. Say you have Ali kill Mona, right? So Mona here, in her dying breath, okay, Ali has stabbed her 3 times, right? Mona here made a statement to Zack who was passing by, and Mona later died. Yeah, Mona said to Zack, Ali stabbed me, and then she died. Now the statement made by Mona here, who is a third party to Zack, can be used to implicate Ali. And the statement of Mona here, which we have discussed last time under Section 32 sub 1 sub A, can also be considered under Section 21A, because Mona here is making an admission as to who caused her death. Now, maknanya, this particular statement made by Mona here, if it is repeated by Zack in the court, can be dying declaration. It can also be an admission under Section 21A. Having said that, Section 21A is very seldom used. In fact, it was never used. The one that is normally used will be under Section 32 sub 1 sub A. I think because the nature of the statement under 32 sub 1 sub A, it relates to the cause of death rather than merely being an admission under Section 21. That's why they use this one more compared to 21A. Right? Now let's look at the second one under 21. Yeah, under Section 21 sub 2. Yeah. Now sub B. Under Section 21 sub B, an admission may be proved by or on behalf of the person making it when it consists of a statement of the existence of any state of mind or body relevant or in issue made or about the time when the statement of body or body existed is accompanied by conduct rendering the falsehood improbable. Now, if you look at Section 21 subsection B here, you have the word here, state of mind and state of body or bodily feeling. This one you can cross-refer to Section 11, 14 and 15 when we discuss about similar facts evidence. So it means that under Section 21B, the statement is related to similar facts evidence. Instead of it being brought under similar facts evidence, it is brought under Section 21B. So that will be Section 21B, yeah, an admission. It is also a third party admission. Now, the other one, the one that is mostly used when you talk about Section 21 will be Section 21C. Section 21C can be a first party admission. Now, the case that can reflect Section 21B will be the case of Lau Kian Boon. The case of Lau Kian Boon. Now, what happened in the case of Lau Kian Boon here is that you may have here the accused person here killed a victim. Yeah, he stabbed, he basically used parang to kill the victim, and he made a statement to his housemate, that is PW. He said to the housemate, I have killed a man. Right? The issue here, if PW here is to testify in the court, under which provision does it fall under? Remember, the statement that A made here is that I have killed V. Now, if you look at the definition, it will fall under definition of a confession, because here A will eventually be charged and he said, I have killed B. So if you look at definition of confession under 17 subsection 2, this is actually a confession under 17 subsection 2. Now, if you want to bring the statement made by PW here of what A said, yeah, you cannot bring it as confession, even though the definition falls under confession. However, the relevancy and admissibility of this particular statement must fall within Section 21C. Why is this so? Yeah, this is so because for it to fall under confession, right, the statement has to be made by the person either to police officer rank inspector and above or to the magistrate, right? So if the statement is not made to either one of those two persons, it cannot be regarded as a legal confession. Having said that, if it is confession under 17 subsection 2, the relevancy of it must comply with section 24 to 30 of the Evidence Act. So since this is actually provision under section 25, this is a provision under section 26, right? The statement that the accused person said to PW here does not fall under one of the provisions in confession, therefore it will be regarded as an admission under section 21C. Do you get that? So this is the something that you have to bear in mind, that if you have an admission, a first party admission like the one in the case of Law529, then it will be tendered as an admission under section 21 sub C, even though the statement is actually a confession. Now this is what happened in the case of, this is what the provision says, yeah, relating to, okay, what transpired in this incident. Yeah, you have, if you recall, last time there was rumors that this person Haziq here had a sexual relationship with a man. There was video caught of them having that activity, and Haziq here made a statement, a press statement through his Facebook. So what he did was that he admitted that the person who committed that crime was me and my partner was so and so. So his statement under the definition fall as a confession because he admitted that I was the one who committed the crime, right? However, remember, Haziq made the statement while he is not in police custody. He made the statement while he is a free man. He was never put in custody, and he did not make a statement to any authority. He did not make a statement to police officer rank inspector and above. He did not make the statement to the magistrate. Therefore, the statement made by Haziq here, even though it may be confession in terms of definition, the relevancy and admissibility of that particular statement falls under section 21C as an admission. Okay? I hope you got that, yeah? Alright, so that will be basically admission under section 21. Right, now let's look at section 22. Now, under section 22, when oral admission as to contents of document are relevant, oral admission as to the contents of a document are not relevant unless and until the party proposing to prove them shows that he is entitled to give secondary evidence of the contents of the document under the rules hereinafter contained, or unless the genuineness of the document produced is in question. Now, under section 22, you're talking about, so you have a document here. Katakanlah this is a contract. So this is a sale and purchase agreement. You have the terms of the agreement. Basically, there is no oral evidence can be tendered to vary the agreement. I believe you studied this one in your law of contract last time. You have the case of Alan McKnight. Basically, when you have a written agreement, you cannot have oral evidence to vary the content of the agreement. This is actually provided for under section, let me look, no, section 91, 92 and 93 of the Evidence Act. So section 91, 92, 93 says that if you have a written agreement, you cannot vary it. Subsequent oral evidence cannot be used to vary it, except you can only use, maknanya oral evidence can be tendered relating to the document if the person is giving secondary evidence. Maknanya this one you have to cross-refer to section 63 of the Evidence Act. If you refer to section 63 of the Evidence Act, secondary evidence includes E. Oral account of the content of a document given by person who has himself. C. So, maknanya dalam section 63C. Say for example, you have here a third party who actually see the sale and purchase agreement, he read through it, he witnessed it, he read through it, and then the original is missing, the third party here can give evidence as to the content of this document because his evidence can be regarded as secondary evidence under Section 63C. That is what it meant by that. Or another one, you're talking about the genuineness of the document. Maknanya, the third party here is giving evidence relating to, katakanlah, the genuineness of the document. Maknanya document tulen. So that one you can use, the third party statement can be tendered as evidence in the court. Otherwise, under general rule, whatever oral statement that you made relating to a document, it is not relevant, not admissible to vary the content of a document, except for the one under Section 22. Okay? So that will be Section 22. Now, what we have discussed so far is that we have discussed about the definition of admission. We have distinguished admission from confession. We have identified, since admission allows for a third party making the statement to implicate the person, so we also have discussed who this third party are. So basically, the third party must be someone who falls under Section 18, 19, 20, 21, or 22 of the Evidence Act. Alright. So one more section that we have to discuss under admission will be under Section 23. Now, Section 23 is very, very important in the sense that Section 23 provides you with what we call as privileged communication. Right? Privileged communication. Now, in our previous sections, when we look at 17 subsection 1 and subsequently under section 18 to subsection 20 to section 22, all of those sections reflect that admission can be relevant and admissible. Yeah? However, under section 23, you have an admission. This admission contains privileged communication. Because the admission is a privileged communication, as a general rule, the admission is not relevant, not admissible. Now, bear in mind, when we talk about admission under Section 23, Section 23 is a provision which is based on public policy. This is a provision which is to encourage discussion, negotiation, to end matters before going to the main trial. So that is actually the aim of privileged communication. Now let's look at here. What is privileged communication before we look at the drawings? Now when we talk about privileged communication, right? In civil cases, no admission is relevant if it is made either upon an express condition that evidence of it is not to be given, or under circumstances from which the court can infer that the parties agreed together that evidence of it should not be given. Right? Now, admission under Section 23 here, or privileged communication under Section 23 here, is only be allowed to be used for civil cases. It means that there is a communication, but it is not allowed to be tendered as evidence in the court. It is protected as privileged communication only if you are dealing with civil cases. Right? And, okay, so maknanya the implication of Section 23 is that it does not allow any attempt to bring the communication as evidence in the court, even though in the communication you have an admission which is very detrimental to the person making it. Yeah? Right. Now, if you look at here, okay. If you look at here, there are several conditions that you have to bear in mind under Section 23. That is, number one, there must be an express condition, right? Under Section 23, there will be privileged communication. The communication will be regarded as privileged if there was an express condition saying that any communication cannot be tendered as evidence in the court, or the court may infer. And as I told you just now, this law on privileged communication is actually based on public policy to enlarge the process of negotiation so that it can be settled without the need to go to the court. You have that in the case of Rush and Tomkin, and in Malaysia you have the case of Malayan Banking Berhad. Now let's look at mana ni nak pergi? Sekejap. How do you go about here? Okay. Now let's look at the privileged communication. What happened here? Say for example, right, you have here A and B, right? A is the plaintiff, B is the defendant. They entered into a contract, right? They entered into a contract. However, there's some kind of a disagreement. A is now suing B for breach of contract. So A is suing B for breach of contract. Now, maybe when you have it in civil cases, what happened here is that if you have a summons file, you are not going to have your trial in 1 year. Normally, there will be quite a number of interlocutory applications to resolve some issues that is not so important. And at the end of the day, maybe after 2 or 3 years, even 5 years, only you go to the main trial. Now, the process of a negotiation, so the long process of interlocutory application here comes along the way where you negotiate. So you will have the opportunity to negotiate with the parties to settle your dispute. Now what happened here is that katakanlah A here is now negotiating. So they are negotiating, right? So the lawyer for A sent a letter to B. Yeah, the lawyer for A sent a letter to B saying that, ataupun they might be negotiating face to face in a meeting. Yeah, A says that, well, we admit that this is our liability. However, to have a win-win situation, we suggest that. Remember, the aim of negotiation for settlement is for both parties to have a win-win situation. Right? To have a win-win situation, sometimes you need to have an opportunity to discuss matters without fear of being sued. You do not want to have a situation where I tak nak cakap, kalau I cakap nanti, I kena saman. Ataupun my statement can be used as evidence in the court. You do not want to have that kind of situation. That is why you have Section 23. Section 23 is to allow that kind of communication to happen without fear that your communication can be used against you in the court. So what happened here is that maybe in the communication, A is admitting, the plaintiff here is admitting some kind of liability. And D, in a counter communication, admitted a degree of liability. Yeah, D also admitted liability. So what happened here is that you are negotiating. Section 23 is basically disallow any letter or communication that happens during this time from being tendered as evidence in the court. Now, what are the conditions for you to rely on Section 23? Section 23 says that there must be either an express condition, or it could be implied by the court. Now, when you talk about an express condition, example of an express condition is when you have the letter which has the word without prejudice. So, without prejudice is an example of an express condition which you put on your communication to prevent or to tell the other parties that, well, we are negotiating. I'm putting my express condition here saying that you cannot bring this letter as evidence in the court. So that is what it meant. So without prejudice here is an example of an express condition indicating that I do not want this particular letter to be tendered as evidence in the court. Now, what will happen here is that, okay, if you have this particular letter, then your communication will be privileged. And remember, the protection under Section 23 is given only if it is negotiation for settlement. So you are negotiating for settlement. So if you are not negotiating and if it is not for settlement, then the privilege under Section 23 will not going to be accorded to you. Alright? So maknanya it has to be negotiating for settlement. What happened here if Your letter has the word without prejudice, but the content is not negotiating for settlement. What will happen? Now, if you have a letter, a communication that has the word without prejudice, but inside there, the communication is not actually negotiation for settlement, then the court has the duty or has the discretion to lift the label and allow for the letter to be tendered as evidence in the court. Alright, so this is actually found in the case of Dusun Desaru, which gives you this principle of law. Alright, I give you an example on this privileged communication. Katakanlah, say for example you have Ali here who was driving his car. He was driving very fast, it was raining, he did not see Abu who was walking at the lane besides the road, and he knocked Abu down. Abu katakanlah is a marathon runner. He has been involved in marathon activities for the last few years, and he is also katakanlah a designer. So as a result of the accident, he lost his leg, he lost his hands. So now what happened here is that Abu now is going to sue Ali for negligence. Right? When Abu is suing Ali for negligence, so Abu will of course appoint his own lawyer. So Abu is the plaintiff, you have the plaintiff lawyer who will be negotiating on behalf of Abu, and you will also have Ali here. Now Ali here, since he was driving a car and it was covered by insurance, Ali's lawyer will normally be the insurance lawyer. Insurance company lawyer. So he will be, this particular lawyer here will be representing the insurance company on behalf of Ali. Now what happened here is that katakanlah the lawyer for Abu here, the lawyer for Abu here has to estimate how much he wants, how much the damages that is suffered by Abu. So this is what you call, he will have to do what you call a quantum of damages. Dia akan kira damages dia. Katakanlah, Abu here is claiming RM500,000 for the injury and loss of income suffered by him. So what will happen is that the lawyer for Abu will send a letter to the lawyer for Ali asking him to pay 500,000, right, to settle the claim out of court. Now the letter normally will have the word without prejudice, because if you have the word without prejudice, it means that I do not want this letter to be part of evidence in the court. So that's why it has to be without prejudice. So if you have this letter, so they are negotiating, and then of course the lawyer for Ali will have to respond. So they will reply, katakan instruction from the insurance company, offer dia 50,000. So the insurance company will make a counter offer, right? Please, 500,000 is too much. Alright, without admission to liability, we agree to offer you 50,000. Okay, that is what insurance company do. They will normally offer the lowest possible, And then if Abu is not happy, dia akan counter offer. No, this is too bad. I retain, it is 500,000. Okay, dia akan lagi negotiate lagi. Okay, in that case, we increase it to 100,000. These are communication that happens through letters between two solicitors, and what you find that this will be negotiation for settlement. They are negotiating to solve this case out of court. Katakanlah eventually Ali is willing to pay, Ali's insurance company is willing to pay 300,000, and Abu now has been waiting for this case for 4 years, 4 tahun dah tergantung-gantung kes tu. So Abu may advise the lawyer to say that yes, we will accept. That is what the aim of Section 23, so that you can get settlement out of court, right? So now what happened here is that these are negotiation for settlement. The moment you have this and you have the word without prejudice, it means that this particular letter, which has negotiation for settlement, will be protected under Section 23. It will be a privileged communication, cannot be tendered as evidence in the court. Now remember, under the law of evidence in section 23, this privilege here can be waived. Yeah, it can be waived. However, for it to be waived, maknanya you do not want to rely on section 23, you want to produce this particular evidence in the court. The waiver can only be allowed if both parties, the plaintiff and the defendant, agree to the waiver. Now what will happen here in some situation, maybe you have quantum of damages here, so they want to put it in the agreed bundle and disagreed bundle. Okay, this one could be in the it could be within the bundle for the plaintiff. So the plaintiff nak letak dekat dalam dokumen dia that is letter of offer together with the assessment of damages. They want to attach it. Kalau ada perkataan without prejudice, what will happen here? You have to get consent from the other party to get it waived and put it inside the document in the court. So that is the position, yeah? Alright. So, what I meant to say here, if you look at section 23 here, you'll find that, okay, if it is negotiation for settlement, then privilege will be accorded under section 23. And section 23 does not apply in the sense that there will be no privilege communication if there is no negotiation for settlement, even though there may be the word without prejudice. So it is supposed to be privilege, cuma pada label, court will lift that privilege label and look inside whether it is negotiation for settlement or not, yeah? And the case of Hu Simoy says that, right, even though you have the word without prejudice on the communication, it may be privileged. However, the privileged communication can be tendered as evidence in the court if the content of the letter have terms in which the agreement is reached upon. Right? That is a situation in Hu Simoy. General rule, you cannot bring the communication except when you have this to be the evidence of the terms of your agreement. Okay, and the other one will be privilege. Right? So on this note, basically, what can I explain to you now? So under section 17, subsection 1, we have admission, and the relevancy of admission falls under section 18 until 23 of the Evidence Act. That will be the law relating to relevancy and admissibility of an admission. Remember, admission can apply in both civil and criminal cases. Having said that, most of it will be used for civil cases. Alright, with this, I end up the discussion on admission. In our next slide, we are going to look at confession.